Good morning, everyone.
Good morning.
Morning.
Okay, so I just have a few matters on this calendar and hopefully we'll get everybody in and out of here quickly. Hopefully y'all can get back to, I don't know, preparing for Thanksgiving. Okay, so the first case I have on the calendar is Windward Community Association versus Earl and Catherine Bruce. Who do I have here on that matter?
Good morning, Your Honor. Frank Buddy for the plaintiff.
Okay. And Mr. Buddy, I understand this is a default matter, but had you had any
I can't
contact?
hear you. Your Honor, I'm sorry, I can't hear you at all. Are you
Can
on
everybody
mute?
else hear me or no?
Yes, I
No.
can.
Okay. Sorry, Mr. Ayub, I think, hang on, let me send you something. Mr. Freehoff, can you send him something in the chat that everybody else can hear me?
Yes, Judge, I will do that.
Okay, thank you.
I
Mr.
gotta
Booth,
stop printing right now. I'm in court. Turn that off.
Mr. Booth, I understand that
Yes.
you, this is a default matter, but had you had any contact with the defendants in this case?
I haven't personally had contact with him recently. I don't see any recent indication or file, but I do believe that he's on the call this morning, Your Honor.
Oh, okay. Do I have someone here on behalf of Mr. or Ms. Bruce?
Yes, this is Earl Bruce. Good
Oh,
morning.
hello, sir. Can you turn your video on for me, sir? Thank you. Hi. Oh, there you are. Hi, Mr. Bruce. How are you, sir?
Good morning. How are you? I'm good.
I'm doing fine, thank you. Mr. Bood, how long do you think this will take in terms of your brief presentation?
We'll just be presenting the attorney's fees, Your Honor, so no more than 5 minutes.
Okay. Mr. Bruce, what I'm going to do is I have several cases on my calendar. I'm just going to call and make sure everybody's here, and then I'm going to circle back to you and Mr. Bood. Okay, sir?
Okay, thank you.
You just wait just a moment. Thank you. The owners at Lakeview versus Katrina Keegler and James Neal. Mr.
Morning.
Bell, I see that you're here. Do we have Mr. Neal here or Ms. Keegler? Mr. Bell, had you had a chance to speak to Mr. Neal? Because that was why we reset the matter.
Yes, Your Honor. I sent him a breakdown that we prepare of amounts owed and just asked him to make an offer based on that. He did. So I know we had a good email for him and everything. The board made a counter offer, which I sent to him, I believe either yesterday or Sunday, and haven't heard anything. I expected him to be here.
Okay.
My witness is here, Ms. Phillips. So we really anticipated having a contested hearing, but he never responded to the counter offer, and he's not here either.
Okay. Well, we will wait a few moments
Hello?
and see.
Good morning.
Good morning, sir. Can you tell me your name?
Mr. Sloan?
Okay.
That's him.
Okay,
I
thank you,
can't
sir.
hear you guys that good.
There seems to be some sort of difficulty with that this morning, but everybody else can hear us. Mr. Neal, or Mr. Sloan, Mr. Freehoff, can you text him or chat him and let him know that he needs to log out and log back in again because we can't hear him?
Yes, Judge, I'll do that.
Thank you. And then the last case I had is the sheriff versus Ivan Trent Redmond, Atlanta Asset Recovery for an interpleader final hearing for excess tax proceeds. I've not seen, doesn't mean it hasn't already been sent. I've just not seen any sort of consent order. Where are we? Who do I have here on behalf of that one and where are we on it? Hi, Mr. Clark.
Good morning,
And
Your
hi,
Honor.
Mr. Ayub.
Yeah,
And
good
Ms.
morning, Your Honor.
Keeley.
First of all, I apologize for not being able to hear at first. I don't
No,
know.
no worries.
There was something weird where you had to click it twice that I'd never seen before. Anyway, it was popping up on our screen. But what I was going to say is I have prepared a final order. It's ready to go. There were two competing claims on it, though, and I just wanted to see at this hearing those two people what they had to present, if anything. I think I know who the money goes to, but I just wanted to make sure before we presented a consent order to you that everybody got a chance to be heard, because one of them's pro se, and I don't like to do deals with pro se people if until they've had a chance to be before the court.
And I very much appreciate that, Mr. Ayub. Now, my review of the file in advance of the hearing was that everyone had been served and that the only entity that filed a claim asserting entitlement to the funds was Atlanta Asset Recovery, asserting that they were the the owners at the time of the taking, but it's possible, did I overlook something? I mean, obviously there was Mr. Redmond and some others, but I didn't see that anyone had filed an answer or a claim after service.
So Mr. Redmond filed a claim with the sheriff's department. And he
Okay,
was served with the complaint. And just out of an abundance of caution, because of how close it was from he transferred his interest maybe 3 days before the tax sale. And I just wanted to make sure that, he understood what he did, and if he wanted to show up today, give him 5 seconds. If he doesn't show up, then we're good to go. I've got a consent order ready to go that gives the sheriff its fees and Atlanta Asset the rest of the money.
okay. Thank you, Mr. Ayub.
Just being on the safe side with that.
No, I very much appreciate that. Ms. Keeley, anything to add on behalf of the tax commissioner?
No, Your Honor, we have no claim, but you moved it so fast, we didn't have a chance to get out before this morning.
Well, that's actually on purpose. I'm happy to let y'all out if y'all can manage it. But generally, my point is to just try and get us to this point, because then we'll already know who the actual claimants are, where if there's a dispute, and let everybody else just go or get to a consent order if and when we can. So
We appreciate that. We're just looking to be dismissed. We have no claim
Yes,
to
ma'am.
the
And the
Okay,
consent
perfect.
order will do that for you. Don't worry.
excellent.
Thanks.
And Mr. Clark, you represent Atlanta, the Asset Recovery Company, is that right?
That's right, Judge. And I checked this morning. I didn't see any other answers, and I wasn't aware that anybody had even filed one with the sheriff. But as far as I know, my client would be entitled to the money.
Mr. Freehoff, any indication if we had any contact from Mr. Redmond?
We have not, Your Honor.
Okay, that's all I needed to know.
Okay, well, if you guys will sit tight, I'm gonna run through the rest of my calendar and just give him a few more minutes to log in, and then we'll get to you guys again. And if Mr. Redmond still isn't here, then we'll go from there, okay?
Sounds good.
Thank you.
Um,
Mr. Bood and Mr. Bruce.
Yes, yes, ma'am.
So Mr. Bruce, just to help, I don't know if you have any experience with the legal system, or if you're a lawyer or paralegal or anything like that, but I just want to sort of let you know what we're about to do. So today is the day for a hearing where, and Mr. Sloan, the same applies to you as well. But today was the day for the court to have a default hearing. And the reason is that the record indicates that a lawsuit was filed by the Homeowners Association where you live, and based on some assessments that had not been paid. And the complaint where they say, we want to recover this amount from you, we're suing you, was filed and served back in October. And typically you have 30 days, not typically, you do have 30 days to answer, and you did not. And then the time for you to have moved to open default as a matter of right has also passed. And so what we're doing today is Mr. Bood is going to present the additional damages that he believes that his client is entitled to, and then you'll have a chance to respond. The reason that I lay all that out for you is that the time for you to have argued that you didn't owe the money is past now because you did not file an answer, but you can still argue about the amount of damages that they're claiming if that's what you choose to do. So I just wanted to sort of let you know what the scope of our discussion might be today. Do you understand, Mr. Bruce?
Yes, I think I understand.
Okay, and you can ask questions if you need to during that process, but with that, Mr. Bood, I'm going to go ahead and let you go ahead.
Yes, Your Honor. As shown in our verified complaint, we're seeking principal in the amount of $3,530 and interest in the amount of $48.17. In addition, we are seeking attorney's fees and court costs. And as to that, I can testify that my name is Frank Buddy. I'm an attorney licensed to practice law in the state of Georgia in good standing. I've been admitted in the state for 10 years. I'm associated with the law firm Coulter and Sierra. The hourly rate that we charge the association is $275, and the paralegals in our firm bill a rate of $115 per hour. Myself and the other attorneys supervise, oversee, and manage all the work done by paralegals. Here, the association has incurred a total of $1,807 in attorney's fees and $485.31 in court costs and expenses through the date of today's trial. I believe we've already submitted a statement of our time to the court with our motion for default. In addition, I did bill an additional 1.5 hours for preparing and attending for today's hearing. I reviewed the attorney's fee statements in this matter, and the fees incurred in this case are reasonable in light of the work done and are customary for the community association practice in Georgia. And therefore, we'd ask the court to enter judgment in favor of the association in the amount of $5,870.48.
But what was that total again, sir?
$5,870.48.
And it sounded as if the only difference between that and the proposed order that you had previously sent over was the attorney's fees. Can you give me that total? I thought you said it was 1,800 and
$1,807.
and the remaining amounts that you previously submitted of the principal of $3,530, interest in the amount of $48.17, and costs and expenses in the amount of $485.31. Those have all remained the same.
That has all remained the same, yes, Your Honor.
Okay. Okay, thank you, Mr. Buddy. I don't know why I pronounced your name wrong, and I apologize.
No problem at all, Your Honor.
Mr. Bruce,
Yes, ma'am.
did you want to address the court regarding this matter, regarding the amount of attorney's fees that Mr. Buddy has asserted on behalf of the association, et cetera?
Yes, I spoke to, I guess that's the paralegal. And no excuse, Your Honor, but like, I'm actually working now. I had to stop what I was doing to get to this. And in the several of the meetings back when they were sending, I guess Windward were sending these, I guess, video, something similar to this. I wasn't available. I had to work. I can't stop what I'm doing. I did it today because hopefully this will be over, but I countered an offer. I think Julie Adderhole was I don't know if she's an attorney or paralegal for the company. And she texted me, she called me. We spoke about 3 weeks prior, and she told me she was gonna go back, I guess, to the attorneys, because I think she said she was a paralegal, and then we could start negotiating. So she sent me the offer similar to what he just said, 5,000 and something. I counter offered, offering to pay, I think about 2,200, because I was going from the initial fee for my roof. It was like $1,300, and I was going to pay. They put in it there $840 for my which I'm not sure why this brought in, but for my association's dues, right? So I agreed to pay $840 plus the original $1,300, which came to like $2,200, and she I guess spoke to them about 4 or 5 days later. She countered with their offer of like 4,500. I then tried to counter, and the next thing I didn't hear back. I got this letter in the mail. So I guess that's what their counter was, this particular letter in the mail. And I'm like, if we're negotiating, which I do for a living for sports, then how does it go from you don't send back a counter to, okay, here's a letter, you need to be on a Zoom call at 9 in the morning on Tuesday? And so that will be my complaint. Also, with, I think these are excessive fees. There's a column, and I'm not an attorney, but I negotiate sports management for 25 years, NIL deals and all types of things. And there's something on here. I have it in there's a 2,500 assessment fee of 2,500. I think that's what the one was, 1,300. These attorney fees, the management collection, the court costs, and all these things. It started with me doing the original, and I know I can't take my case, but I'm just, he came and he gave his background. I'm gonna give my background. I've been staying in the community for 12 years. June will be 12 years. I had roof damage, which I did in the original thing, and we've switched once or twice with the management people, so I don't know who. In my 12 years, I think we've had maybe 1 or 2 management groups. So I had roof damage probably 4 years ago, prior to COVID, right? 3 or 4 years ago. I did not complete with State Farm. We did not complete the work. After I had I wanted to say it wasn't possums, it was raccoons. I think it was raccoons had gotten in my roof. At that point, it got to where it was bad, right? There was a big, and they have pictures of this windward. It had gotten so bad, and it was negligent on my part, but it had gotten so bad that you could see it was holes. They'd done burrow holes in parts of my house. And they were actually, when I had to pay the person to come out, he actually took the mother and some babies. They'd done lodged in the master's bedroom above our master bedroom in the roof. And so I made, again, negligent. I'm not looking for excuses. I made a homeowner's decision to immediately, as opposed to going through this long drawn out process that I went through the first time I was trying to get the roof prepared 2 or 3 years earlier. I made a homeowner's decision to pay money to have this escalated. I went by the code, because if I didn't, they would have charged me for that. My roof looks marvelous. I must say that. And so I went and got it done, and they sent me, this is when it started, right? I spoke to someone over there about when they first gave me the $1,300. I think it was $1,300. Don't quote me on it. But when they first gave me the charge, I spoke to them. You know, they said, well, it could be more than this. Just depends on if it goes by neighbor code, this to that to that. Of course, they never called me back to tell me it went by neighbor code. I was just under the assumption that it did go by neighbor code, because if not, they would have charged me for that. And it looked a lot like, well, not a lot like, but it looked like roofs that was in the neighborhood. Actually, my neighbor, my next door person to me, had a tree fall in. They liked what we had done so much. They went and got something very similar. But that's neither here nor there. I'm here to get to some realistic charges, and we can whether it's over time or I want to get this over. I'm tired of having people put things in my mailbox and in my email about paying this fee. I really want to get it over.
Well, I understand that. Thank you for that background context, Mr. Bruce. And, you know, it is similar to what I hear from lots of people, is that what happens is, you know, some event will happen, like a roof issue or something like that, and they'll end up owing an assessment. And if they're not able to pay it immediately, then what ends up happening is they end up with these types of attorney's fees, et cetera, charges. And unfortunately, the reality, Mr. Bruce, is that all of what Mr. Buddy has requested is written right into the declaration that governs your homeowners association. And so it allows them to make these assessments. And more importantly, it allows them to file suit to recover on those assessments. The best thing that I can tell you, though, Mr. Bruce, is that in my experience, and I think Mr. Buddy will back this up, is that two things I want to point out. Number one, the fact that they were negotiating with you and then they sent you a hearing notice, those are two separate things, right? Because the notice had to go out because this is a hearing that was scheduled for today, and nobody had control over that except me. I'm the one that said we're having a hearing today. But number two, my experience is that even when a judgment gets entered, the homeowners association is typically still very willing to work something out, whether it be a payment plan or further continued negotiations to get it resolved. But unfortunately, by the time it gets to me, I only have a couple of choices, which are to look at the case and determine if, in fact, it is in default, which I've already indicated it is in default because more than 30 days have passed since you were served with a complaint and no answer was filed. And so you became in default at that point, and the 15 days that would have allowed you to open that default as a matter of right have also passed. And so then the only real issue, as Mr. Buddy was presenting, is whether or not the amount of attorney's fees that have been presented and costs, et cetera, are excessive. And although the problem is lawyers are expensive, and although it seems like a lot of money relative to the amount that you originally owed on the assessment, it does appear to me to be reasonable and necessary under the circumstances. And so the amount that they have requested, the total judgment in the amount of $5,870.48, is the amount that will, is an appropriate amount for the judgment. And so I am going to go ahead and enter default judgment in favor in favor of Windward Community Association. But again, Mr. Bruce, I would encourage you, if you were talking before with Ms. Adderholt, to reach out to her and see what continued negotiations y'all can try and have. Because as I said, it has been my experience that just because there's a judgment entered, there still is a possibility for a negotiated resolution, and certainly for payment plans or things that make it more affordable for you to make that payment, to pay it back eventually.
Okay. What is the total as of today? Because they're changing.
The judgment that I'm going to be entering is in the amount of $5,870.48, and the additional amount, the assessment amount that you would have been notified about, $3,530, has not changed. The change, as Mr. Buddy mentioned, was as to a slight number of additional hours of attorney time that had not previously been presented for him to prepare for, be present at the hearing, and take care of those matters.
So one more time, Your Honor, 3530 was what again?
$3,530 was the assessment, whatever it was for. It sounded like from talking to you, it was for some combination of assessments associated with roof damage, as well as the actual monthly or assessment dues that are required to be members. But that's the total amount, and then the additional amounts, and it will be itemized on the order that I'm entering, so you'll be able to see it. But that is the order that I'm going to enter, and that will be the conclusion of this hearing. And so Mr. Buddy and Mr. Bruce, you both may be excused. And I hope that even under the circumstances, Mr. Bruce, I hope you have a lovely Thanksgiving.
Thank you, people.
Thank you, sir. Have a
Yes,
good
sir.
day. Mr. Bell,
Yes, Your Honor.
Mr. Sloan. Mr. Sloan, are you laying down?
No, ma'am.
Okay. Well, it looked like you were, I was concerned that it looked like you were laying down, and I was also concerned that it looked like you were sleeping there, which is probably why it looked like you were laying down. I just wanted to remind you that you're in court. I know you're sitting in your house and not physically in a courtroom, but this is still a court proceeding. So in any event, Mr. Bell, if you would please go.
You see it?
No, it's fine. I understand, Mr. Sloan. It's fine. I just wanted to ask. Mr. Bell, if you want to please go ahead with your presentation, sir.
Yes, Your Honor. Ms. Phillips, can you unmute yourself and raise your right hand, please? Do you swear or affirm the testimony given on the matter pending before the court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, can you introduce yourself to the court, please?
My name is Nicole Phillips.
And what is your relationship with plaintiff, the owners of Lakeview Homeowners Association?
I am the property manager for the association.
And in that role, are you familiar with the books and records of the association?
Yes, I am.
Are you also familiar with the governing documents, the declaration recorded in Fulton County?
Yes.
And under Article 5, does the association have the authority to levy assessments for common area maintenance?
Yes, they do.
And also pursuant to Article 5, if an owner becomes delinquent, does the association have the authority to levy late fees, cost of collection, interest, and reasonable attorney's fees?
Yes.
Have you reviewed this account, the Keegler Neal account, in preparation for today's hearing?
Yes, I have.
And have these two owners paid all of their assessments owed to the association?
No, they haven't.
What is the principal amount that these defendants owe the association?
$3,051.40.
And how about the interest that these owners owe the association?
$285.61.
And then we're here today, so the association has obtained legal counsel to collect this amount. Can you let the court know what the court costs, litigation expenses, and attorney's fees that the association has incurred are?
The court costs are $258.25. The litigation costs and expenses are $276.02. And the attorney's fees are $3,838.50.
And do you also have just a total amount owed that you can tell the court?
$7,709.78.
Your Honor, that's all I have for Ms. Phillips.
Okay. Mr. Bell, want to present your attorney?
Well, I
fees?
didn't know if Mr. Sloan wanted to ask Ms. Phillips anything.
Mr. Sloan, do you have any questions for Ms. Phillips?
I would like to know, how do you assess the fees and the that is attached to the original $63 monthly fee? How,
When you, Mr. Sloan, let me try and help you out here to make sure you're asking what you want to know. Are you asking about attorney's fees, or are you asking about the assessment the homeowners association made?
The attorney fees are outrageous regardless. The fees though, that are
So the assessments that the homeowners association asserted against you, is that what you're asking about?
right,
Okay.
right. The trash can fees, the whatever their fees are for whatever, like we're fined in my neighborhood for their lack of. We have, as people in the community have communicated, that we don't have some necessities or amenities that other neighborhoods have. So we're fined for creating those amenities because they won't. Last year, I was
Well, hang on, Mr. Sloan, I apologize for interrupting, but right now, procedural part that we're at is for you to ask Ms. Phillips questions if you have any questions for her. If you want to present anything on your own behalf, there will be a time for that. But right now, if you have questions for Ms. Phillips, this would be the time for you to ask for those questions.
okay. Well, I'm asking, where do they come up with those fees from? Who's the person, doing that and making the assessments? And I really want to know, like, why is there no understanding to those situations? No kind of leeway or nothing. It just, hey, you're gonna be this or that, and if you and everything is just I'm just trying to figure out, like, how do they come up with this stuff? Basically in the situation that in any point that they can just say, hey, you owe this or you owe that, and there's nothing you can do about it. You can't never reach them. I never met her. I never know who she was. I never seen her a day in my life. So how she the property manager and nobody knows what, what I'm saying? Nobody never met her. Nobody never sees why or what she's coming up with, or any understanding of the whole process. So
Understood.
I want to know where the excessive fees come from and why.
Ms. Phillips, if you could talk generally about where the assessments arose in this case.
Okay, so we have an inspector that goes out to basically inspect the properties to see if there are any violations according to your governing documents for your association. So anything you're fined for, it's stated in your documents that that's a violation for your community. We don't do anything beyond what we can do. Any violation gets a courtesy notice first. So if there is something going on at your property and you feel like, hey, this is temporary, I'll move it. You have time to move it or take care of it before the fines are assessed to your property. You can contact us, you can email us. You said that you can't get anybody on the phone.
Never.
No.
Okay.
Stop. No. Ms. Phillips, I apologize. Mr. Neal or Mr. Sloan, so you're clear, the way questioning of a witness works is she gets to answer your question and then you can ask another question when she's done, but we don't interrupt. So hold on to that thought of whatever it is you want to follow up or dispute and let her finish her question. Go ahead, Ms. Phillips.
Thank you. So that's basically the way that works. And then on top of the fines, there are assessments on the account. from, looks like you paid the account off in June of last year, but have not made any additional payments since then. So as far as the assessments, there's assessments and late fees from June 2023 or 2023 to current. So that's basically what comprises your balance.
Thank you, Ms. Phillips. Mr. Sloan, did you have additional questions or want to follow up with her?
When she said I paid since last year, I
Right,
was
she said you paid through June of 2023 for assessments.
paid for assessments, fees. I paid everything off last year, and for June, I was thinking it was for the end of the year. I wasn't sure how it really works. Like I said, they're never able to be reached ever. Nobody ever answers the phone. Nobody never emails you back. The letters come in originally as a $50 fine or 150. There's never any warnings.
Mr. Sloan, forgive me for interrupting you, but as you heard me
I've been in
saying
that
a moment
community
ago,
since-
when I was, I'm sorry, sir.
Okay, go ahead. Go ahead.
As you heard me telling the other gentleman that was here this morning, and I think I might have mentioned it to you last time you were here. I understand that this process can be frustrating. I understand that it probably doesn't. There are things you could say from your perspective that you're trying to say right now about how they don't provide good service or whatever it is, right? But here's the thing is legally, Mr. Sloan, you have passed the time for you to assert, deny or defend the underlying legal allegations because you were served with a complaint and you did not answer the complaint. And so today's hearing was about damages, right? It's about the amounts that Ms. Phillips claims that the association is entitled to recover, and that Mr. Bell claims that he is entitled, or well, that the association is entitled to recover in terms of attorney's fees. And so if you could focus your questions or discussion with the court on the amounts, that would be helpful, because while I understand that you're probably very frustrated with issues associated with what they didn't do or notices you might not have gotten, those are defenses that you would have raised had you answered the complaint, but you did not answer the complaint.
I did. I went down there personally. I went to their office personally to negotiate and try to come up with something. And like I said, and the same thing with the other guy. I understand that life happens. They don't understand that life happens. I gave them in the amounts, and we're speaking on numbers. I gave them almost $13,000 last summer. So I would think they would press somebody else to have an understanding that they may not be the only person that I owe. And I've ran into severe hardship since then. I kind of gave everything I had. I've lost numerous family members, including my mom, and my business has been on the downslope. I tried to explain that to them, like trying to keep myself in business, keep my bills paid. Everything is behind. So I have to prioritize and make sure that I keep my kids with somewhere to live at times. And it has slipped away because I don't know where to. I've been there since 2004. I've had the issue, never agreed with it, never been able to communicate with them. But I just paid them, and they were awarded a judgment for me being 3 minutes late logging in last year without me being able to say anything. So similar situation happened this year, but it didn't work in my favor that way. Wasn't dismissed with prejudice. So I had went to Mr. Bell's leading, I guess, attorney at the time, or whoever he works with, and tried to come up with something. And I went back through the file that they sent me, Mr. Bell sent me last week, and the monthly from June to now is in a total of like $1,200. From June to now, $1,200, and the fees total up to and all with the monthly installments of $63 from last June to now is $29.84. I submitted that to I will have to look at my email real quick. I submitted that to Mr. Bell last week, and I was trying to see if they were willing to negotiate monthly thing or something like that. Everything is my back against the wall. I'm trying to do something right now. I'm out on a contract. So my trash can was left on the street last week, and I'll be gone for 30 days. So if they're finding me and I wanted to make sure my trash got out, they have an excessive fine of $50 a day. At 7 days, that's $350. So,
Well, Mr. Sloan, I listen, I do not mean to discount how frustrating that must be and the difficulties that you are dealing with. And I understand how important it is that you have to figure out when you're having economic difficulties, what to prioritize, right? But unfortunately, when you choose to live in a neighborhood that is governed by an association document like the one that you live in,
they
those
all
are
are. The whole world
those
is
are
a
the
racket.
rules, Mr. Sloan. Those are the rules that apply. And so I understand that you take issue with it, but unfortunately, that is where we are today. And so I understand that you are frustrated with the fees and that sort of thing. But do you have any other questions for Ms. Phillips regarding the amount of the assessments, fines, and fees that were assessed against you by the homeowners association?
It's not any questions because I can't. When I was current, I was reaching out trying to get on the board so I could be somewhere, but you can't reach anybody. So it's like it's no point in having any questions. They have their people in place. They do what they gonna do. They have their racket is set up, and if you slipping or if you're not on point for whatever reason, they're gonna railroad you. And that's all I have to say about the situation. If I'm asking Mr. Bell, I submitted that to them to try to cover the fees and the late fines, to ask them would they accept that and waive some of this stuff, as because like I said, I don't have it. And for the amount to go from 5,000 to 7,000 and a couple of months, I don't have that. I didn't have the 5,000. So I don't have the 3,000. So
I understand, Mr. Sloan.
time, it's like, how do you fix the situation? Are you here to try to take my house, or do you just really trying to work with me? Now you can reach me when you want to take me down, but you can't be reached when I'm trying to keep myself current. Like, don't even know, like, if the
Mr. Sloan,
payment,
Mr. Sloan, Mr. Sloan, there is a time and a place for you to say all this. But again, my question is, do you have any more questions? Mr. Sloan, you have to stop talking when I'm talking. Do you have any more questions for Ms. Phillips right now?
No.
Thank you. Mr. Bell, would you like to present regarding your attorney's fees, please?
Yes, Your Honor. State in my place that I've been a practicing attorney licensed in Georgia since 2019. Coming up on 3 years of doing the community association work in Atlanta. We did 13.9 hours of legal work on this file. That does include up and through today's appearance. Our hourly rates for attorney work are $300. For paralegal work, it's $195. Those rates are customary in the Atlanta area for the community association business, and the amounts that Ms. Phillips testified to regarding court costs, litigation expenses, and attorney's fees are the same amounts that I have. And that amount is reasonable given the amount of work that has been done on this, and just would ask that the court award that total of $7,709.78 to the association.
Mr. Bell, I'm going to ask if Mr. Sloan has any questions for you. But before I do, if you could just address a little bit about, listen, I understand sometimes there are reasons that the attorney's fees go up. But typically for an amount relatively low, I don't usually see an amount of attorney's fees that is higher than the assessment. Can you address a little bit about what might be responsible for that or how that might have occurred in this case, Mr. Bell?
Yes, Your Honor. So in every case, we send 3 letters. Sent a letter in April, sent a letter in June, sent a letter in July before we even file our complaint. We do a couple of title searches. We do one on the very front end to make sure we're going after the right people. We do another after we send our last letter prior to filing a lawsuit to make sure, again, we're going after the right person. At that time, we also do a bankruptcy search. Then we effect service on the defendants. There were 2 defendants, so 2 separate costs associated with this one. Then we filed our motion for default judgment. The only thing excessive, quote unquote excessive or different about this one is 2 court appearances. And I would say that we didn't, well, 2 things we didn't charge for. We didn't charge for preparation today. We're just charging for attendance today because I already prepared last week for this one. And then I don't know how long Mr. Sloan was at my office speaking with the partner. That partner charges $3.50 an hour. There's not even a billing entry on that. So whatever, I assume he probably, if he had met with me, I probably have charged a half hour or however long he met with me, that would have been included. So I would just say that's not even included in what I have. I'm happy to send this to Mr. Freehoff for your review. But I think the only thing that calls this one, normally we'd be about 11 and a half hours at this point in a default judgment. The only difference is that this is our second appearance. And that's not Mr. Sloan's fault. I can't put that on him. Ms. Phillips was having technical issues. I was at the beginning until I left the DeKalb County Courthouse and got outside. So I understand if the court wants to take that into consideration as to reasonableness, but that's the only thing I see different in this one.
Okay, thank you, Mr. Bell. Mr. Sloan, do you have any questions for Mr. Bell regarding the attorney's fees that the Homeowners Association is seeking?
I don't have any question regarding the attorney fees. I have a question regarding the letters. I didn't receive any letters. In April of this year, my mom was on life support. That happened on my birthday, April 14th, 2024. That was my wake-up call. I've been in the hospital that whole time that she was on life support, which was for right at 3 weeks. All right. I didn't receive a letter. And back in July, I have these on record. On June, when they said they sent it or whatever, my mom went back into another situation with the pneumonia, her illnesses and stuff, was on life support again. And July, she was on life support as well, and then she passed. I've been dealing with that for months. I haven't been home. I've been in the hospital all year.
Mr. Sloan, forgive me for Mr. Sloan, forgive me for interrupting you, but first, I'm very sorry for what your family is struggling with. I know how difficult it is when you have to care for an ailing family member. But again, the argument that you didn't receive notice, number one, is an argument that you could have and should have asserted in an answer to the complaint that was served on you and Ms. Kegler. And number two, the fact that you were not home to receive them doesn't mean that those letters were not sent to an address where you were expected to receive them. And so, again, I don't mean to sound uncaring about the difficulties that you are dealing with, sir, but those are not legally relevant matters for the court to consider right now. Did you have anything else that you wanted to ask or address the court or ask Mr. Bell?
I'm asking them to make some kind of have a heart in this situation. Like, I just gave you all I had, and I split the bill. That's why I came up with the $3,000. That's covering the fines and fees, or they could put it all, waive that, and put all the $3,000 towards the attorney fees, whatever. You know what I'm saying? It's a lose situation for me. I have to make sure that once I get my situation back up under my feet, that I make sure I send these $63 in. I know it may seem minute, but it doesn't take long for them to railroad you about it. And like I said, I was under the impression that they had moved everything through the end of the year when I paid almost $13,000 getting stuff caught up. I said we got 2 associations in the thing as well. Like, man, it's a whole racket, and I've been there trying to hold on to it. I get rid of it. I've been listening to my kids. I can't take it anymore because it's not fair to anybody in America that has to deal with the HOA.
I understand, sir, and that is why I do not live in a neighborhood with an HOA. And I know lots of people who don't live in neighborhoods with HOAs because you have to deal with those rules and these types of assessments. I understand, but that is neither here nor there. At the end of the day, as I have said a couple of times, it is unfortunate, given everything that your family has been dealing with, Mr. Sloan. But the fact of the matter is that you were served with this complaint back in September. There was supposed to have been an answer filed that you could have asserted all these defenses about asserting that you didn't receive notice or that you had made partial payment, et cetera, within 30 days. And that didn't happen. And
I actually did
that was,
excuse me, Your Honor, I actually did do that. And they
no,
had,
sir, you didn't. We've already been through this. You did not. It is not in my record, which
no, I
means
told you in my,
Mr. Sloan,
I didn't file on this court thing, but I went to them.
Mr. Sloan, stop. I understand. What I am saying is that an answer was supposed to be filed to this complaint in the court, and that did not happen. And so therefore, your ability to challenge the underlying legal facts of the case has passed. This today was an opportunity for you to challenge the amounts that were asserted by the Homeowners Association and that were asserted by Mr. Bell. I have heard, Mr. Sloan, it's not your turn to talk anymore, sir. I gave you a good bit of time to speak and to address both Ms. Phillips and Ms. Bell and the court, and your time to speak is over now, Mr. Sloan, unless I ask you a question. So as I was saying, the amounts that have been presented by the Homeowners Association and the amount that was presented by Mr. Bell are reasonable and necessary under the circumstances. And so the judgment that was sought by Mr. Bell in the amount of $7,709.78 on behalf of the owners at Lakeview Homeowners Association is the judgment that I'm going to enter. Mr. Sloan, I just want to let you know, sir, that as you probably heard me tell another gentleman on this call today, it has been my experience, and Mr. Bell mentioned when you were first logging in, and I think you said you couldn't hear us, Mr. Bell mentioned that there had been some effort at negotiation and some back and forth. And so I encourage you to continue that effort at negotiation regarding resolving this case with the Homeowners Association and or Mr. Bell's office, because it has been my experience that even once a judgment is entered, the Homeowners Association and the lawyers are still willing to work with the homeowners so that you can continue to live in your house and pay some amount either through negotiation or through monthly payments. They are typically willing to accommodate people in that regard. And so I encourage you to continue the efforts that you had started to try and negotiate to resolve this case. But the outcome of today's hearing is that I'm going to enter a final judgment in the amount of $7,709.78. And Mr. Bell, the proposed order, the proposed petition that you sent, the proposed order you sent over includes, that is the correct dollar amount, right? The $7,709.98. Is that correct?
That's correct, Your Honor. I realized that I needed to update or send an updated one to Mr. Freehoff, and I did this morning, about 8:30 or so.
Yeah, that's what I was looking at, and I was just making sure it was the right one. So that is going to be my ruling. Again, Mr. Sloan, I encourage you to continue reaching out to the attorneys to see if there's some resolution that can be had or something that can be worked out in terms of monthly payments. But that is the conclusion of today's hearing, and Mr. Sloan, Ms. Phillips, and Mr. Bell, you may all be excused. And even under the circumstances, I hope, Mr. Sloan especially, that you'll have a good Thanksgiving. Thank you and have a good day. Okay, the last matter, Mr. Ayub, is the sheriff's office versus the Mr. Redmond and the Atlanta Asset Recovery. And so I don't see that Mr. Redmond has joined us at any time. Mr. Freehoff, can you confirm good notice?
Yes, Judge, I think I can.
Okay.
And Your Honor, I actually, while we were sitting here, I double checked everything on him, and he actually I knew there was a reason why I wanted to make sure he didn't show up, is because he contacted our office and did an acknowledgement of service. And so that made me think that he wanted to make a claim. I guess he never did. So just while we were sitting and listening to the interesting arguments about homeowners association fees, I did a consent order.
Use that time wisely, huh, Mr. Ayub?
Yes, I did up a consent order. One question I had for you about it though was, and we did it with Atlanta Assets getting their money and the sheriff getting their attorney fees, and nobody objected. The only thing is that Ethan Pham also filed a answer of no opposition for the city. He's not here. Ethan's a great guy, but I've noticed he might take a couple of days, 2 or 3 days to respond sometimes. Would you be willing to sign a consent order that does not include him, or would you prefer we wait to see if he wants to consent to it?
No, I mean, I don't mind if he consents or not. I mean, generally what I do, and you guys have been appeared in front of me enough times, I have a fairly standard form that basically, as long as you say, here are all the excess funds, this is how they came to exist, this is who made a claim, everybody was served and nobody else made a claim, then here's how the money's being distributed. That's entirely fine with me. And for the parties that will consent, have them consent. And for anyone who did not appear and also didn't make a claim, I'm not that worried about proceeding to just a regular order as to the non-consenting parties.
Great. I'll email the order to Mr. Freehoff in a minute and get rid of Ethan's consent line, because that will probably save us 2 or 3 days, and you can get it quicker for the parties. Okay.
And Mr. Freehoff, if you'll do me a favor when we're done, don't end the meeting, because the young man, James Robertson, is he's a first-year law student at Mercer, and so he was observing today. I think he's going to be interning with me this summer, and so I wanted to have a chance to talk with him and let him ask questions. So if you'll just leave that Zoom going, James and I will use it when the hearing is over. Did you have something else that you needed to address, Mr. Freehoff, regarding this matter?
Well, I have confirmed that Mr. Pham has not yet opened the hearing notice, so that's why he's not here today.
Well, he probably wasn't paying attention because he'd already filed a notice of no claim. So, Mr. Ayub, did you have? I'm sorry.
Yeah, real quick question: is your daughter enjoying FSU?
Yes, she loves it.
Okay, because my daughter might be going there and wanted to know.
Well, if you want to connect them, let me know who it is, and we can connect them through Instagram or however they actually connect with one another. And I'm sure she'd love to share with it because she loves it.
Okay, that's what I've heard, and I knew we discussed this before, and so she wanted to know. And I know you had told me something about in-state tuition. So
yes.
Like they're able to somehow I guess it's a scholarship or something they have, or
yes, exactly. Do you have any family members who live in Florida?
I do.
Okay, so yeah, my daughter, they have a grandparents waiver program in Florida, and so if any of your parents or your wife's parents live in Florida, they can apply when they get admitted and ask to get a grandparent tuition waiver, and it covers all 4 years. You get in-state tuition for the whole time.
Oh, wow.
But the nice thing is Florida State is really good about their out-of-state. They welcome out-of-state students, and they try to offer in-state adjustments for as many reasons as they can find, has been my experience. So.
Oh, that's great. Well, great. Thank you for the information. Have a
No,
great
happy to. Like I
Thanksgiving.
said, and reach out because I'm happy to connect them if you'd like to. Like I said, my daughter loves it and would be happy to tell anybody about how much they like it. So
Okay, I will. I'll send you an email and maybe you can shoot me back her email or
sure,
contact or
absolutely.
whatever. And I'll put my
Okay.
daughter on it. So she's trying to figure out where to go right now. All right.
Okay,
Thank you
great.
so much. Have a great Thanksgiving.
Excellent. Everybody have a good Thanksgiving. Thanks so much.
Okay. Bye, guys.
Bye-bye. Hey, James.
Hello.
How you doing?
I'm doing well. I'm glad I'm on my Thanksgiving break.
Yeah, my Thanksgiving break starts basically after this hearing. I still have a few orders to work on writing that Mitch keeps sending me emails saying I still have a few outstanding orders. But other than that, I think there's probably going to be some baking in my future
Okay.
rather than working today. So what have you been up to? And mostly, like I said, I did want to just do a general catch up. And then as the last time you came and visited, there's always like weird stuff that comes up that you're like, gosh, I wish I understood what that was. Sometimes it's self-explanatory, but I also wanted to give you a chance to ask any questions you might have about what we were doing today.
Okay, sure. So I'll start with sort of what I've been doing. Obviously, you've been through 1L at Mercer. It's a lot sometimes.
Yes.
I've had a great time. Actually, the content has been fun for me. Contracts, I'm still trying to. I feel like you need a crystal ball to figure out sort of what's going on sometimes.
Yes. Yes.
That's been although it's funny because some of my friends who they majored in business or economics type stuff as well, they seem to get it, and I'm like, I'm like, that was my undergrad, and I don't understand what's going on half the time.
Yes, it is. It's funny. Contracts was very confusing to me as well in law school, and yet that's what I ended up doing for most of my career was litigating about contracts. And so I think you'll find it will start to make sense at some point. But at the end of the day, it's always they're mostly just trying to get you to think about how contracts work and don't ever go too far down the road of what is consideration, because if you do, you'll just get lost.
Yeah. I've loved torts and criminal law have been fun. That may be just sort of where I was sort of more predisposed to be interested in anyway. And the professor I have for criminal law, he is very exacting in his analysis.
Who's teaching criminal law now?
I'm part of the first group that had Professor Byers. He's
Okay. I'm not familiar, but not surprised. We usually get really good professors at Mercer, but
yeah, he's wonderful, and I think my legal analysis has gotten better in other classes because of his class.
That's always good. That's a good feeling.
I had torts with Dean Wilkins,
Okay.
and I really like her. She's fantastic, and it was my first class of the day. It's always good to begin with that, and it's not as rigorous sometimes. Not rigorous, that's the wrong word. It's not as in depth as some of the contracts cases where it's like, okay, who was the offerer and how do I find that out?
Well, and also, I mean, the other problem I know in torts, you got to go way back to, old cases, but especially in contracts, because the idea